ಕಂಪ್ಲೇಂಟಾ?
No. It's on a police report.
ಅದಕ್ಕೆ ನಿಮಗೆ ಟೈಮ್ ಕೊಡಬಾರ್ದು. ಎಸ್.
ಅಲ್ಲ, ನಾನು ಕೊಟ್ಟ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಎಲ್ಲ
Melons,
ಸಿಬಿಐ ಕೇಸು,
they're
ಪೊಲೀಸ್
in all,
ಚಾರ್ಜ್ ಶೀಟ್.
I'm sorry, they're all,
ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್.
Melons, in all 7 judgments, starting with this Jagdish Ram Melons versus State of Rajasthan, 2004,
Yes.
relevant portion, paragraph 10, at Melons, page 6, paragraph 10.
Yes.
Then Melons, the second judgment is Bhushan Kumar versus State, 2012 5 SCC 424. The relevant paragraph, my lords, is at paragraph 11 at page 13 and paragraph 18, my lords.
Yes.
Refer to in
My lords,
Vikas.
then,
Yes.
Refer to in Vikas.
yes.
Yes.
Then comes the next judgment, State of Gujarat versus Arfos. My lords has relied on this. I will point out, my lords, how my lords relied on this judgment.
2019.
2019-20.
Hassan Fatah.
Yes, my lords.
Yes.
In this, the relevant paragraphs, my lords. Paragraph 16 at page 25. I'm 25. Then, my lords, at page 27, paragraph 21 till 23, my lords, which we get at page 28. Everywhere, my lords, they show the difference between a private complaint and when it's on a police report. Thereafter, my lords, the next important judgment, I'm sorry, my lords, in that judgment, 23, ಮತ್ತೆ one more paragraph at 39 ಇದೆ, 39,
Yes.
which is at page 34. Then, my lords, in a criminal revision petition, the coordinate bench of our court, my lords, the very same contention now was taken in that case, my lords. I think my learned senior had appeared in that matter also, my lords. He took the same contention application of mind on a police report in Jayachandra's case. The relevant paragraph there, my lords, in Jayachandra's case is paragraph 14 at page 56, my lords. The court would say, no, insofar as a police report, it is not required that you have to disclose a lot in it. Then, my lords, the next judgment
Yes.
is Pradeep Wadiyar. This is the most important.
Most important 108.8. Yes.
Adralli, my lords, Pradeep Wadiyar alli,
Pradeep Podar, paragraph 108.8.
ಅದಕ್ಕಿಂತ ಮೊದಲು paragraph 10.
No,
Podar.
Pradeep Podar cognizance gene there is one issue.
ಹೌದು, ಆ ಇಶ್ಯೂ ಅಲ್ಲಿ, my
related.
lords, paragraph
ಅದರಲ್ಲಿ
10.
conclusion is paragraph 108. ಅದರಲ್ಲಿ 108.8 ನೋಡಿ.
ಹೌದು, my lords, paragraph 11 ಅಲ್ಲಿ they extract the cognizance order. That is most relevant, my lords.
Yes.
My lords should get that at page 9.
ಅದರಲ್ಲೂ ಅಷ್ಟೇ ಏನೂ ಇರಲಿಲ್ಲ.
Yeah.
ಆ cognizance order, if you want to see, Justice Michael Kunna ಅವ್ರ judgment ಅದು.
ಹೌದು,
He affirmed that.
even in Pradeep Wadiyar,
It's affirmed only.
they extract that, my lords.
Yes, yes.
They extract, my lords, ಒಂದೇ ಒಂದು ನಿಮಿಷ, page 95, paragraph 11 ಅಲ್ಲಿ, what it says is, peruse the final report.
Yes.
Cognizance is taken against accused 1 to 5. Register the case. Register the case and issue summons to 1 to 5, returnable by so and so. This is what it says in Pradeep Wadiyar, and the contention taken was there is no application of mind. Now, answering that, my lords, in Pradeep Wadiyar, they distinguish the two aspects. When it is on a private complaint, how the cognizance order and issuance of process should be. When it is on a private complaint, on a police report, how it should be. My lords, that commences from paragraph 85, my lords, page 132 ali.
Yes.
They deal with all the earlier rulings on this, my lords.
Yes.
Paragraph 85 in the 91 varege, my lords. The whole issue is covered. Then,
Yes.
my lords, following this,
Counsel, mark the paragraphs you're relying on.
adralli moor judgment avurdu.
Give it.
Moor judgment, I can point out what is different. Our first judgment is on the basis of a private complaint. My lords, first judgment, private complaint. The last of the judgment, 306 ಅಲ್ಲಿ, it was a B report. B report ಮೇಲೆ 202 proceeding agi, then when there was issuance of process, there was no application of mind. That the court said is wrong. You have a B report with you, you do a 202 inquiry, and then you're going to be issuing process, you should show application of mind anta. Whereas in all these 7 judgments, my lords, which I am relying on, it is on the case of police reports, how it should be done. Even they have extracted, my lords, what's the cognizance taken. Now, my lords has extracted the cognizance taken. I'll point out my lords' judgment, my lords. 2 judgments of my lords. My lords, first is Ratan Babulal My lords should get it at page 151.
Page 33 of my judgment. See page 34, the next page, I have said it, the perusal at the order of taking of cognizance does bear application of mind.
Absolutely.
So it is not applicable.
Absolutely.
Yes.
Then, my lords, the other judgment where my lords felt there is no application
That
of
was an
mind.
error because PC Act that I was dealing with PC Act. So I have said so. The subsequent judgments of the Supreme Court are here. Yes, sir.
So, my
Anything
lords,
else? Sir?
now as it stands, my lords, and kindly what was read in our judgment was our cognizance order, my lords, page
52.
552. Please notice, my lords, I'll just read this, what has been taken as cognizance here. Peruse the charge sheet and all the documents submitted along with the charge sheet by the investigating agency. 552, my lords. On perusal of the same, this court is satisfied at this stage that prima facie offense has been committed by the accused as alleged. The charge sheet and its enclosed papers satisfies that there exists sufficient materials to proceed against the accused. Therefore, cognizance is taken under section 191B of CRPC for offences under section 418, 420, 465, 466, 120B against the accused persons. Office to register the case as criminal case against the accused for so and put up. Issue summons to the accused. So in my respectful submission, this is all that would be required in a police report for taking cognizance, my lords. My lords, I've placed all the judgments on this point. I leave to the court there. So I had to breeze through it.
It should not turn counterproductive to you.
ಆ ಕಡೆ ಹೋಗ್ಬೇಕು.
ಅದಕ್ಕೆ when you come to this side, this should not turn
One
counterproductive.
But my lords,
191
because
B
these are aspects of law, my lords, we had to place whatever is there, my lords.
Correct.
Whether
No, I'm
it
not-
works to our
The
benefit or
lighter
not.
ways, can't help. Yes, ಮಾರ್ಕ್ ಅಂದ್ರೆ ಅದಲ್ಲ, ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ ಹಾಕೊಡಿ ಸಾಕು. ನೀವು ಪೇಂಟ್ ಮಾಡ್ಕೊಡ್ಬೇಡಿ.
my lords, ನನ್ನ ಅವ್ರದ್ರಲ್ಲೂ ಮಾರ್ಕ್ ಮಾಡಿದ್ದೀನಿ ನಾನು ಅವ್ರದ್ದು ಮಾಡಿ.
I want only the paragraph numbers.
Yes.
Sir, I for one,
Yes, my lords. Could I
is
give
always
my-
the firm opinion that any order, whether it is 156(3) or 204 or cognizance being taken at 191B, 190B,
191A.
191A or B, only two.
Yes,
See, taking of cognizance ಅಷ್ಟೇ, issuance of process and 204.
not four, correct.
So,
Correct.
ಇದರಲ್ಲಿ, if it does not bear any application of mind, it definitely
My
causes.
lords, what
a
happened
problem.
in Pradeep Vader was exactly this. They said when an investigation
No
has come.
problem. Post Pradeep Poder, there are many.
No, all those. I've produced even post Pradeep Vader. My lords,
Post Pradeep Poder ಯಾವ್ದು ಇಲ್ಲ ನಿಮ್ದು.
how do?
ವಿಕಾಸ್
No.
My lords,
ವಿಕಾಸ್
Tamil
ಶಫಿ
judgment
ಅಹಮದ್
ಇದೆ.
ಅಂದಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
ವಿಕಾಸ್
but
ಶಫಿ
Supreme
ಅಹಮದ್
Court
ಇವೆರಡೇ
ಇದೆಯಲ್ಲ.
ಇರೋದು.
No, no.
Post
Supreme-
Pradeep Poder,
My
you
lords-
give me, post Pradeep Poder, you give me one judgment of the apex court which follows Pradeep Poder and says reason should not be there.
Reasons?
Should
My
not be.
lords, no,
Reasons.
Pradeep Vader also doesn't say that. My lords, Pradeep Vader says,
Pradeep Poder says at 108.8 that when the cognizance is taken on a police report, that is the charge sheet filed, it need not bear reasons like how cognizance
elaborate
is taken
reasons. Yes, my lords.
on a
That's-
private complaint.
Absolutely.
All
Absolutely.
right?
Absolutely.
Yes.
Now, if it's a private complaint, my lords, they may have to say, what is the gist of the allegation? Because there's no investigation done.
True.
Why you are satisfied that the gist
That-
constitutes the offense?
That does not mean that the duty of the concerned court to record at least some semblance of application of mind is obviated.
My lords, I leave it to the court, my lords. This is what I find so
Yes,
far
yes.
as police reports are
we'll-
concerned.
we'll
Because,
con-
my lords, I may also say this, I'm sure Lalit Senior will also agree. More than 80%, my lords, more than 80% of all the cognizance orders on police
Are like
reports,
this, correct? Should there not be a correction?
my lords, the
You tell me, should there not be a correction?
my lords may have to lay
We
it down,
also
my
follow
lords.
what is happening throughout and say, yes, this is all right. That is why apex court has later on written, there should be a correction.
My lords, I leave it to my lords to, if it's going to be, at least then, my lords may at least point out what is expected to be there, my lords, at least to that extent.
What
Do they-
Supreme Court has said, we will.
They don't say, my lords, what is expected to be there to
ಈಗ
show
ವಿಕಾಸ್ ಚಂದ್ರ ಅಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ.
My lords, Vikas Chandra Ali,
We'll hear.
my lords,
senior
Vikas Chandra Ali, 306 B report. B report
Yes.
ಆದ ನಂತರ
Yes.
202 inquiry. Inquiry ಆದ ನಂತರ there was cognizance taken without application of mind. That is Vikas Chandra. That's the last of the judgments, 2024. And my lords, in all the judgments, we find Pradeep Vader.
That's the problem.
We find Pradeep
Yes.
Vader. So kindly notice even Vikas Chandra, why it was done, my lords. It was a case of virtually a B report, 202 inquiry and then process being issued.
Assist the court, my lords. I'm led by senior, but.
Senior. Sir.
Please.
Sir, yes.
May I just request your lordship to kindly turn to paragraph 13 in Vikas.
1-3.
1-3, my lord. A close scrutiny of the position of law. My lord, whatever the judgments which Malaran Friend has been referring to or has referred to, my lord, are referred to in this judgment by the Supreme Court, including Bhushan Kumar. Your lordship would get at item number 6 of the judgments. All the judgments have been referred to.
Yes.
Bhushan Kumar, Bhattacharjee, Ramesh Kumar, Nitin Datta, almost all the judgments.
Yes.
A close scrutiny of the position of law revealed from the aforesaid decisions, which are constantly and consistently being followed by this court, would reveal that issuance of summons is a serious matter and therefore shall not be done mechanically, and it shall be done only upon satisfaction of the ground for proceeding further in the matter against a person concerned based on the materials collected during the inquiry. In the aforesaid circumstances, the next question to be considered is whether a summons issued by a magistrate can be interfered with in the exercise of the power under section 482. In the decisions of Bhushan Kumar and another NCT Delhi, and in another judgment, etc., my lord, and Pepsi Foods Limited, etc., this court held that a petition filed under section 482 CRPC for quashing an order summoning the accused is maintainable. There can't be any doubt that once it is held that sine qua non for exercise of the power to issue summons is the subjective satisfaction of the ground for proceeding further, while exercising the power to consider the legality of a summons issued by a magistrate, certainly it is the duty of the court to look into the question as to whether the learned magistrate had applied his mind to form an opinion as to the existence of sufficient ground for proceeding further, and in that regard, to issue summons to face the trial for the offense concerned. Well, this would be important. In this context, we think it appropriate to state that one should understand that taking cognizance empowered under section 190 CRPC and issuing process empowered under section 204 CRPC are different and distinct. See the decision in Sunil Bharati Mittal versus CBI. Well, what needs to be seen is that application of judicial mind at two stages. The first stage is under section 190. It may be under 191A or 191B or 191C. That is for the limited purpose of taking cognizance. I am sure your lordship would certainly agree with me. I would say, my lord, emphatically, that there is little application of mind for the limited purpose of taking cognizance of the offense in exercise of the powers closed upon the magistrate under 191B. It is there. But subsequent thereto, as the Supreme Court has said, taking of cognizance is something totally different from issuance of process under section 204. Whether it is a private complaint or a police report, the court gets the jurisdiction to order issuance of process only under section 204 and not by invoking any other provision under CRPC. But here, there has been absolutely no application, no order as such under section 204, other than saying issue summons.
Yes, we will set right the 80% now.
But even in Shafi Ahmed, well, this is also a state case.
All
Yes.
this is considered. Even if you see this judgment in Sharif Ahmed.
Yes, man, Sharif
Hasan
Ahmed.
Patta is
All this-
considered.
Even Vikas is also
Poder
referred
is
to.
considered.
Sunil Bharti
My
is
lords,
referred
I'll
to.
just point out.
Para
My lords,
17.
Sharif, my lords is seeing Sharif Ahmed.
Yes,
Please
sir.
notice Sharif Ahmed,
Yes,
the
sir.
starting point itself at page
Yes, sir.
48. Page
49
48.
judgments have been referred to.
49 ಅಲ್ಲಿ, paragraph 2 ಅಲ್ಲಿ, please notice what the court considered at line 5, my lords. They've done the judgment in two parts, page 49 ali, my lords.
No problem, sir.
My lords, kindly
We will
notice, the
hold that reasons are
Allah.
required.
first part relates to the legal issue, that is the content of the charge sheet. My lords,
Oh, all of them are on police reports.
yes,
Yes.
my lords,
There are police
which I
reports.
have given, my lords.
Hello, sir has given.
No.
Ah.
There's,
No,
my
it is
lords,
a police report.
I'm sorry, my lords. The
Shafi
very
Ahmed
first,
is the
my
latest
lords,
one.
they're relying on
Vikas Chandra is on private complaint.
Sachin Garg is on a private complaint.
Ah.
My lords, Sharif Ahmed, paragraph 2 may be noticed what it was about. Vikas Chandra was a case where it was a B report, 202 inquiry
is-
and issuance of process. These are the three judgments.
I will hold reasons are necessary.
Anyway,
Yes.
Sunil
it is
Bharati
my
Mittal,
lords,
my lord,
my
is-
lords,
my lord,
So
Sunil